All right, well, switching gears here in New York, a man is taking his employer to court over one of the most highly debated questions relating to the coronavirus. Can companies require their workers to get vaccinated? The plaintiff, Antonio Coronado, is saying that he was furloughed because of his refusal to get the vaccine. Antonio joins us now along with his attorney, David Schwartz. Gentlemen, thank you so much for joining this evening. Antonio, we'll start with you. Talk to me more about what happened and why you decided to file the suit.
I was unlawfully terminated due to religious and personal reasons. I was working for Great Performances for about a year. And when COVID hit, we were mandated to take the COVID test twice a week, which was, okay. I didn't mind. And we had to wear masks, which was, also, I didn't mind either. I didn't mind that either. So basically, up until 3 months ago, I got an email stating that if we don't get the vaccine, we won't be able to work there anymore.
And so, for your reasoning, you do not plan on getting the vaccine at all, and you made that clear to your company?
Yeah.
Okay.
They kept on trying to push me, sending emails, having their employer manager, HR manager come see me, when are you going to get the vaccine? I just didn't want to. I didn't feel comfortable getting the vaccine.
And you were furloughed in the wake of that, correct?
Yeah, I was fired. Mm-hmm.
Okay. David, I want to bring you in here. I know you're an attorney representing Antonio Coronado. What is the case here? What is the case that you were making as to why, in your case, he was wrongfully terminated?
Right. He was wrongfully terminated, and termination is the operative word. You can't just indefinitely furlough someone without pay and not call that a termination. So that's what's known as a constructive termination. And I don't think there's a judge around that's going to disagree that he was constructively terminated. Bottom line is, it's a violation of New York State human rights law, New York City human rights law, and the executive law to terminate someone on the basis of a religious, ethical, or personal conviction. Antonio or any other employee has the right to bodily autonomy, making decisions for their own body and their own health care. Whatever happened to HIPAA and the right to keep personal health care decisions private? All right, that gets thrown out the window here, where the company forces an employee like Antonio to disclose whether or not they got the vaccine or not. Mm-hmm. And then, of course, they're arguing, at least in the court of public opinion, that he didn't come to them with reasonable accommodations. Well, the reasonable accommodations were what he was doing already. He was getting tested twice a week. He was wearing a mask. He was practicing social distancing. The employees were doing all of these things already. So you cannot mandate someone to get a vaccine. And I do think this case should set some precedent in the area. Okay,
so let's talk. David, I want to stick with you here for just a moment, and then Antonio, I'll bring you back in. But I just want to present both sides of the argument here, right? Companies could say that they need to protect their employees, and they might argue that everyone needs to get vaccinated to be there in order to protect their employees and in order to get people back to work, because one of the stories we've been following is that the labor shortage is very real, and some people are still on the sidelines. They don't feel comfortable returning to work just yet because they are concerned about contracting the coronavirus and the health complications that it would cause them. David, I'll start with you. What is your response to that argument by a company?
Yeah. Well, I mean, certainly the CDC has not mandated this vaccine. It's not a mandated vaccine. It's for experimental use only. It's an emergency use authorization only. So legally, there's no vaccine mandate. And the CDC was pretty clear that there would be no vaccine mandate. As far as the safety issue goes, there was safety precautions. Sure, nobody wants anyone to get sick in the workplace. Nobody wants anyone to get sick. But the reasonable precautions were being taken. He was being tested twice a week. Antonio has said that he would be willing to get tested every single day if he had to. He was wearing a mask. He was practicing social distancing. These were the methods that we were using in order to not spread the virus. That's a pretty safe way of operating. He just should not be forced to taking a vaccine that he's personally against taking and make that mandatory. And if it's not mandatory, then you lose your job over it. That's a wrongful termination, and we'll see what the courts say.
So there is some recent guidance that we've seen publicly released from the Equal Employment Opportunity Commission. It says it is legal for employers to require employees physically entering the workplace to be vaccinated as long as they comply with reasonable accommodation provisions. And Antonio, I want to bring you back in here as well. Talk to me more about when you decided to reach out to David for representation and whether or not you're aware of anyone else at your company being let go, indefinitely furloughed, as you were for this very reason.
Well, I honestly just didn't know what to do. I got fired and I just didn't know what to do. I wanted to stand up for myself, so I chose to speak to a lawyer, and there David was. What was the other question? I'm sorry.
Was anyone else at your company that you are aware of also indefinitely furloughed because they did not get the vaccine?
Yeah.
Others were as well. Now, David, I want to bring you in here. Obviously, we're focusing on Antonio and we're hearing from Antonio firsthand, but what about his other peers who were indefinitely furloughed as well? Does that change your case at all?
I'm going to change your classification. They were wrongfully terminated and they were constructively terminated. And yes, my office has received several phone calls, and we'll see what happens. I think next week we'll probably be filing more cases, not in this area, and some different twists on those cases. But I'd rather not comment on them yet until we file the cases.
Antonio, join us again here. According to a New York Post story, a spokesperson for your company, your employer, your former employer, said that the company would be willing to have a dialogue with those who request legitimate accommodation. Are you open to discussions with them?
I highly doubt it.
Do you want to return to that job? Do you want to return to the workforce?
No, I do not.
Not to that particular job. David, is there
Yeah,
any
no.
discussion to be had here with the company about reasonable accommodation?
Sure, they called me. They called me already, so we're discussing it. But Antonio doesn't want to go back to work to this particular company. I know Antonio wants to be gainfully employed at some point, but he doesn't want to go back to a company where he was doing a great job at the company. He loved his job. He was working very hard, very diligent, and they just fired him for not getting this vaccine. And that's very upsetting. And the other people that I'm speaking to are just as upset. They were just as diligent as Antonio in their work, and they took a lot of pride in their job. And you know that, you know, the statute that the guidance, the EOC guidance that you referenced, it talks about reasonable accommodations. Mm-hmm. And certainly the reasonable accommodations were being done. They were being met already here. The masking, the testing, and also the social distancing. They were already being met.
Mm-hmm. David, are there legal precedents that you're referring to here in this case? I mean, obviously, many of us in our lifetime have never seen something as dramatic, truly a worldwide shutdown as we did with the coronavirus these past 14 to 15 months. Is there any legal precedent that you're looking at in making your case?
Yeah, I mean, certainly the U.S. Army, where there's an emergency use only vaccine, where it's experimental and not mandatory. There have been many cases in the U.S. Army where soldiers refused to take the vaccine and they were given an accommodation. So legal precedent, there's not much legal precedent out there, but there's certainly factual precedent that's out there as to what's reasonable under the circumstances. And again, I think I stand by the New York State human rights law and the New York City human rights law. And certainly for personal medical decisions, you can't be fired. You can't be terminated on that basis. So we'll be seeking damages.
Guys, it is such a hotly debated issue right now. We thank you for taking the time, Antonio. We thank you for speaking up and telling your story. That's Antonio Coronado and his attorney, David Schwartz. Guys, we got to leave it there, but thank you again.